we're joined by two very special guests here on Business Tonight. Soli Sorabji, former Attorney General, and Mukul Rohatgi, Senior Supreme Court lawyer, joining for the big debate right here on Business Tonight. Gentlemen, thank you so much for joining us here on the show. Mr. Sorabji, to start off with you, how do you read the court's harsh decision today, harsh observations rather, and its decision today to keep Subrata Roy and other directors in custody till the next hearing, which is on the 11th of March?
Well, I think the court has done the right thing. No one can take the court for granted, however rich and powerful they may be. They have to comply with the directions of the court and the undertakings they've given to court. Because, please understand this, it's not a question of the court, any judge getting angry. It's a question of the authority of the court, the majesty of the law. If you give undertakings and don't comply with them, and trifle with the court over a period of time, then the court has no choice but to enforce its directions by what it has done today. Otherwise, it would have sent a very wrong message that the rich and powerful can get away with it, get away with non-compliance with court's orders. That would have been a sad day. I think what the court has done is the right thing, is send the right message to all, especially to those who think that because of the position and power, they can get away by non-compliance with the court orders.
All right, no matter how rich and powerful you are, there's no getting away from the Supreme Court. Mukul Rohatgi, I did see you nod disapprovingly. Take it away. What is your take on the court's decision today to keep Subrata Roy and other directors of Sahara Group in custody up until the 11th of March?
I personally think that this incarceration is rather harsh. It's not one person, but a large number of people who are being kept in custody. As far as I know, if a person or a corporation has to pay some debt or has to pay some money or deposit money in court, then obviously if money is not paid, the court can take action. But the normal action which a court will take to recover money is to attach all assets belonging to the party, asking the party to file a list of all assets in court on affidavit on oath, get hold of title deeds, that is for removable property, get hold of all shares and movables including money in banks, appropriate all this to a court fund, and then commence auction and sale of these proceeds so as to liquidate the debt. That is the normal manner in which it is done.
Mr. Sorabji, I want you to react to that. Do you agree with Mukul that the court has perhaps been too harsh on Sahara officials and about 10 board members will actually be lodged in Tihar jail up until, of course, when the concrete plan is shared with the court? Is this really a case of the court being once bitten, twice shy? It's not willing to take any chances just yet?
It's not a question of once bitten, twice shy. The court has to maintain the authority of its orders, has to maintain the majesty of law. And those lawyers who feel that the court has been harsh, would they feel the same thing if the client had been ordinary Purushottam Mittal or so-and-so? I don't think so. I don't understand how the laws can say it has been harsh. On the contrary, the court should have been harsher much before today.
Been harsher much before this order. Mukul Rohatgi, let's look at the observations made by the court in the order. It says that most of the investors actually do not even exist. It is accused the Sahara Group of market abuse. Does that not warrant strong action against Subrata Roy?
It is obviously strong action is being taken, but these are matters of merits of a case with which I am not really concerned. I was only talking about the nature of punishment which the court has ordered during the course of these proceedings. And if, obviously, as I told you, if the payments are not found to be valid by a court, the court is entitled to ignore it. It's like saying that if I have to repay a debt to you of 1 lakh and I claim that I paid it to you in cash and I don't have a receipt, obviously you are entitled to say that the money was never paid and no court will believe it. So there is nothing astounding or extraordinary in that.
Mr. Sorabji, comment on that. The Supreme Court has actually rejected the Sahara Group's claims of having refunded money to investors. They've actually called the entire refund process invalid. How do you read into that? How big a setback is that?
I really can't say anything definite about that, except that is SEBI satisfied that they have carried out the order? I don't know about the cash payment and other things. The question is, the court's order has to be carried out in letter and spirit without any ifs and buts. You can't go on making all sorts of suggestions for modifications, for variations. Otherwise there won't be any end to it.
All right, there is no interpretation of a Supreme Court order, if you may, Mr. Sorabji. But let me quickly take this across to Mukul Rohtgi. Mr. Rohtgi, what do you think? The court has actually said a very scathing observation, but it has said that this detention is essential to maintain faith and confidence of our people in the Indian judicial system. These are very strong words, and they seem to indicate that the courts are wary, and they do believe that the Sahara Group has not just cheated investors or market participants or market regulator, it has also taken the courts for a ride. Will you agree with that interpretation?
Well, as I told you, I think it's a little excessive. And to make, one can be a nature of punishment that if somebody violates an order of the court has jurisdiction in contempt to order imprisonment to uphold the majesty of the law for a certain number of days. That's something different. At the moment, the court has not found a person guilty of contempt, has not terminated the proceedings and pronounced a verdict. This is a kind of an interim situation where the court has ordered custody pending further proceedings. This, as I told you, I find a little harsh.
All right, you find it a little harsh, but Mr. Sorabji, if I was just to be the devil's advocate, should courts not have attached property or sold property, taken action on bank accounts? Why did they have to wait for so long? Why did they have to wait up until today?
That's exactly it. That's my point. The court gave him a long rope. They gave him a lot of indulgence. And now the time has come when enough is enough, and Subrata Roy has to carry out the orders of the court.
The courts have indeed given a long rope. That's the view from Soli Sorabji. Mukul Rohtgi, let's talk about the road ahead. How easy is it going to be for the Sahara Group to cough up the cash? 20,000 crores is a lot of money.
See, according to me, what Sahara and other people must do is to honestly put forth before the court what are the assets which they have, what are the nature of properties which they have, make out a list of all properties, find out the title deeds of all properties, make a fair valuation, and give all this to the court, whether it amounts to 20,000 or doesn't amount to 20,000. Even if it is something close to 20,000 or 15,000, the court should be taken in confidence in saying that this is what we have. We can also sell off some offices of ours, we can sell off some assets of ours apart from immovable properties, and we will attempt to give as much as we can. Obviously, if the court has rejected the return of cash to individuals, etc., that cannot be taken into account anymore. And they should go upfront to the court and say, this is the position. Start selling, the court can appoint a committee which can take possession of these properties. And, like large number of these chit fund cases, the courts appoint committees to take possession, and the committee then starts selling. The committee starts calling investors who have to be refunded their money, and a scheme is put in place for starting to refund on a pro rata basis, if not the whole. And that is how you work out these things.
But Mr. Sorabji, there is a reason to be a little skeptic, isn't it? Does Sahara Group have the wherewithal to cough up this much money? 20,000 crores, this will entail sale of property. It's a tedious task. Is there hope ahead?
I think he'll find ways and means. I'm sure he's resourceful enough to cough up the cash. Others have to remain in jail till he does it.
Mr. Rohtgi, before we let you go, and I want you to be candid this evening, did Sahara really make the mistake of taking the legal system, the Supreme Court, the market regulator, just about everybody in the system for granted, and he's perhaps paying a price for it today?
See, you must understand one thing, the arms of the law are very long. Nobody can ever take the Supreme Court for granted. The court also gave long rope. The court was also patient. Obviously, when the court found that things were not happening, the court was maybe forced to take an extreme step. And as I told you in the beginning of this session, that I personally find that this was very excessive, quite excessive. But ultimately, it's the Supreme Court. You cannot take it for a ride. You must respect it and go back to the court, because there is no further appeal from this court. Go back to this court and try and win the confidence of the court. That is what they must do.
All right, win the confidence back, and that's going to be a tall order indeed. But Mr. Sorabji, there are many legal cases that corporate India is involved with various regulators across the country. What is the one big message they should be drawing out of this particular incident today? Subrata Roy spending the next 7 days in Tihar jail. What should they be learning from this?
Well, the only message is that if you give any undertakings to the court, please don't give it with the idea at the back of your mind that you won't carry it out and give some excuse later on to say, for this reason, that reason, I'm unable to carry it out. The lesson is clear. The court is not vindictive, but the court is strict. And if you want to give an undertaking to the court in order to buy and get some relief, please carry out that undertaking or face the consequences. And the consequences will be contempt of court, and contempt of court means you will be in civil prison.